Okay, good morning, everybody. Welcome to the Crest Network Tuesday morning webinar. We're very honored to have with us attorney Harvey Cohen. Just as a quick side note, a couple years ago with the hurricane, I had some significant roof damage, and I'm very thankful for Harvey for taking on that challenge with the insurance company and helping me resolve that, get paid my money, and now I have a new roof. So I have a real live involvement with Mr. Cohen, and it's been a big relief for me to have had that roof replaced by the insurance company. Harvey enlisted in the U.S. Army and ultimately then went on to law school at Stetson University, the College of Law in St. Pete. After graduating from Stetson, Harvey was employed by the state attorney's office as a state prosecutor. He handled thousands of criminal cases, conducted 40 jury trials, executed extensive motion practice, and I can just go on and on and on. There are paragraphs of Harvey's accomplishments and his background. He is known throughout the state of Florida and nationwide as the go-to attorney for cases as it pertains to the restoration industry. He's been a presenter at the RIA and many other trade groups. One of the things that the Cohen Law Group is involved in, very active in the community, the Leukemia Lymphoma Society, the Hope and Help charity for AIDS patients, the SPCA, the Jewish community, the YMCA, Susan G. Komen Foundation, the Down Syndrome Association, and Veterans Association. So welcome, Mr. Cohen.
All right, thank you. Thank you for that introduction. That was great.
Absolutely. Bill Giannone, the other co-founder of the Crest Network, is here on. And Bill, why don't we just start shooting some questions at Mr. Cohen?
That'd be great. I want to thank you, Harvey, very much for sharing part of your morning with us and with our membership. It's really an honor to have you with us. Your level of expertise and your ability to make things very simple for our members and for the restoration community is one of the things that makes you so special. And we want to thank you very much for being with us.
Thank you. Good to see both of you, and thanks for having me.
I appreciate that. Harvey, we talk a lot about large loss. The Crest Network is predominantly large loss. However, we do have many of our members, and we get probably a couple of dozen calls a week from outside people who aren't even members, always asking information. Can you help me out? And it's always about collecting the money. So we know through listening to you at various times when you've presented at the experience and other webinars and seminars you've given, how important the level of documentation is. And obviously, if we're ever going to think about a job or a case, we always have to think that everything we do and say is going to end up in court, and that's kind of the best way to protect ourselves. So what I wanted to do is ask you a couple of questions that I've gotten throughout the last couple of weeks when it became clear that we were going to be able to enlist your expertise, and I'm kind of the funnel now to get everybody else's free advice from you, if that's okay.
Okay, that sounds good.
Let's start at the beginning. With work authorizations, there's this big dispute or question or misnomer in the industry about the validity of a work authorization. Could you just touch a little bit on that? Because, you know, we hear things like, well, it's not a valid contract in court if it doesn't have a dollar amount for the services rendered and it won't stand up. What do we need to have in our work authorizations short of a full price to make them valid legal documents?
Well, that's a good question. And first, before I begin, I just want to, I know you guys are all over the country. So whatever, I'm only licensed in Florida. And So the only actual, advice I can give pertains to Florida. Also, everything that we talk about here today is for, informational purposes only. So, I can give you guys some ideas about contracts and provisions, but it's important that you check with your attorney in your own state. So if you're listening to this or watching this webinar, it's very important that you enlist the services of a licensed attorney in your own state. So that being said, let's start at the beginning. What is a work authorization? If you think about those two words, it allows you to work, right? It's authorizing you to work. It's not a contract. A contract has to have something else. So here, this is the example I tell people. If I tell you, hey, I'll cut your grass for you, and you say, go ahead, what did you give me?
Authorization.
Authorization, right? And then I go cut your grass, and then I say, okay, you owe me $150. And you say, well, I never agreed to that. I just let you cut my grass. So the second part of that, or and I'm not saying actually that it's not a contract, but you understand that basically you gave me authorization to begin work. There's a horrible case. I can't remember. I think it's maybe in Arizona, that it was one of the biggest ones I've ever seen, where somebody had just a plain work authorization, and they did millions of dollars worth of restoration for a big commercial project. And at the end, they went to them and said, okay, now you owe us, here are all our bills. And they went to court, and ultimately the judge said, no, you only have a work authorization. You don't have a contract. So you can imagine that company, that construction restoration company, probably went from, hey, this is the biggest job we've ever had, we're going to make millions, to we're out of business, because they still owe all that money to their employees and everybody else. And I'm sure they paid out all kinds of money, while they're working that job, and got zero. So it is important to make sure that you call your documents what they are. And it's important to call your contract a contract. It can be, some people don't like that word, and they like to call it agreement for services, or, I say call it either an agreement or contract for services. It is important too to have what's called the work authorization inside the document. And that's just part of it that says, listen, we have an agreement that I'm going to come in and do XYZ, whatever it is for, the roofing or restoration or mold remediation, whatever you're in there to do. And also you give me authorization to do this work. So that's part of it. And that's why it's important that I tell everybody, call your documents what they are. If it's a contract, call it a contract. Don't have across the top work authorization. So that's important.
I appreciate that. So it's okay to put the words work authorization and contract for services, or agreement for services?
That's fine.
That's
Of
okay
course,
to list them both.
That's fine. And so like contract drafting 101 is, you call your documents, you title it what this whole thing is. And then each paragraph should have its own title, so you know what you're reading. And then inside each paragraph, it should explain what the paragraph is talking about. And so that's why, like, it's just important to work with attorneys who understand the restoration industry and contracts, and get to the point. For example, I've been hired by people that they give me their contract, that they paid some attorney $5,000 or $10,000 to draft this contract, and it's like 20 pages long. And I go, who's going to sign that? Nobody's going to sign that contract. If you came to my house and I was like, just dry out my house, that, a pipe broke, and then you want me to sign a 20-page document, it's not going to happen. And I've had to have discussions with attorneys that I work with that do a lot of contract drafting. And I have to explain to them, listen, in the real world, that doesn't work like that. If you have to have like a 1-pager, or maybe 2 front and back, something like that, but it can't be 20 pages long, and you can't have somebody thinking, oh, I'm not signing mortgage documents to buy a new house. I just want, whatever. I just want this dried out, or I want you to, fix this problem, whatever I'm dealing with, no matter how large or small. So sometimes you see a lot of overkill.
Bill,
Appreciate that. Yes, Dick.
if I can interrupt. Harvey, we have a number of experts in the industry state that your price list should accompany your contract. And that's probably especially in a large loss commercial situation. Well, as you can imagine, a price list can be a dozen pages. And so you add that to a 2 or 3 page contract, suddenly you have 15 or 18 pages. What about that?
Well, I don't see that as bad. In other words, if you were sitting down with an asset owner, on a large loss, and you have a 2 or 3 pager, and then you have attached, as your pricing guide, you could say, here's our pricing guideline. You could have that, whatever, 15 pages of line items. That's fine. They're going to understand, okay, this is basically, a DHU costs this, a air mover costs this, whatever it is, down the list. And that's fine. You just attach it. It's not like, I don't think they're going to be scared of that, where it's just a price list, compared to some of the contracts that I've seen that are just overkill. They have way too much information. And I think when you're dealing, I know you guys we're talking about large loss and commercial claims, but probably 90% of my clients who do large loss also do, residential or smaller jobs. So I think there's a big difference when you're dealing with, and this is another level. If you're dealing with an asset owner who, has some kind of like business intelligence and they know what they're talking about, that will be a different level than, for example, if you deal with a board that in a condo association, and when you're trying to explain to 6 people that are volunteers that are retired from Ohio, that moved down here, or it's hard to explain these things to them, and that might be a little bit more difficult, and you have a harder time explaining it. But I don't think that would be, in my opinion, right? In the real world, I think that's easy enough to explain. Hey, here's my contract that's like 2 or 3 pages. This is what, we're going to do this. You're going to do that. By the way, here's my attachment. And this just lists out all of the prices, for anything that we may run into. Here's a list of all the prices that you will be responsible for ultimately.
Okay, that makes sense. Thank you.
Mm-hmm.
And since Dick went there, we're going to stay on the topic of price lists for a little bit, Harvey.
Okay.
One of the major issues that we're all facing in this industry is trying to make sure that we can be fairly compensated for our cost of doing business. And
Right.
I'm sure you're aware, but over the years, one of the biggest knocks against Xactimate has been that it's kind of price fixing the marketplace, and it's not allowing for the personalization of invoicing based on our own particular needs and costs.
Right.
So there has been a big push in the last 5 to 10 years of independent restorers pricing their services outside of the Xactimate price list.
Right.
However, there's been that equal and opposite reaction from the insurance companies, basically saying we're paying one price and that's it. What can a restorer do to at least give them some leverage, or is there any leverage that they can have when they're invoicing $30 for an air mover as opposed to $27.50,
Right.
for instance?
Well, that's another great question. And what I tell people is, number one, your pricing has to be reasonable. So what does that mean? What that means, what do other people charge, in your area? So, the thing is, for example, if you don't want to use that, some sort of pricing guideline, and you talk to other people in your industry, and you talk to 50 people and go, how much do you guys charge for example, air mover? Oh, you charge 32, you charge 29, you charge 30, okay, well, I'm going to be somewhere in the middle there, or even towards the top. I've had clients that say, I'm not going to be the cheapest. I'm going to be the most expensive, but I'm going to do a great job. And that's what matters. That the extra, going the extra mile, not cutting corners, things like that.
What leverage do we have? Because right now we're basically being told, well, this is what we're reimbursing the policy holder for.
Right.
And if you want to charge more, that's on you. Pound sand, go get it from your client, which, even though that is a practical answer, it's not very practical if we want to have a long-lasting relationship with lead sources like plumbers, for instance, where we're constantly harassing their people for extra money.
Right.
Is there something, because again, outside of certain states where there's these assignment of benefits, we're not parties to that, that contract. So is there anything we can do to try to force them, for lack of a better term, to pay our price?
Well, and so you nailed it there, that you are not the client or the customer of the insurance company unless you have an AOB. But so if you're dealing with, your client is the homeowner or the asset owner. So they are responsible to you to pay your reasonable bills. And if they don't, your recourse is really against them, but their recourse is against the insurance company. So for example, if you give a reasonable bill to somebody and the insurance company, which they often do, underpay, then the asset owner or homeowner they have the right to go after their insurance company and say, hey, you owe me this money. Not only that when we get involved in claims, doesn't matter what size, there's a big difference, in my opinion, called what's called costs incurred compared to an estimate. So for example, we might have write up a roof for a community we estimated at $10 million. Okay, that's just an estimate. We just wrote this down. There's a big difference between that and a contractor that says, listen, I put roofs on all of your buildings. You owe me $10 million. That's a cost incurred. That's something that the asset owner brings to the insurance company. Go, listen, this is how much I owe this guy. This isn't an estimate. This isn't a negotiation. I owe this company $10 million. So, there's a big difference with that. But ultimately, unless you have an assignment of benefits, you have to remember your contract is with the asset owner and their contract is with the insurance company.
Right. And you brought up so many great points, and I just want to touch on one of them, and it's the whole term of incurred costs. In all my years of coaching restoration companies, I'm always really quick to make sure that they understand that under no circumstances are they ever to get into a conversation with the adjuster regarding the policy. We're not lawyers and we're not PAs and we're not legally allowed to discuss the policy. But a really key thing is the language and the definition of incurred costs. Because one of the things that I've coached for years, and I've found it to work to varying degrees of success, is if we can get the homeowner to pay our bill and then seek reimbursement from the insurance company, as opposed to the insurance company cutting the check to us, that there's a far greater chance of them paying as long as we are fair and reasonable. Do you find that to be a practice as well, or is that just anecdotal?
100%. No, we run into those all the time. Those are, in my opinion, just like you said, those are great cases where the contractor has already done the work. The asset owner has already paid the contractor. We represent the asset owner against the insurance company, and exactly that. Listen, this isn't, some kind of fiction or an estimate. This is how much our client has already paid. So you owe the full reimbursement of that, maybe minus the deductible, but you owe that amount, and that's it, and not a penny more and not a penny less. So those are good cases. We have that happen quite often, especially roofing, with hurricane claims, that somebody will get tired of fighting with their insurance company. So they'll pay the roofer, here, just put on a new roof for us. And what we do when we get involved with that, we give the insurance company notice that we're going to do it. We give them ample opportunity to do any inspections that they have to do, but we tell them by this date, this is the deal, insurance company. You have, 10 days or 15 days to do any additional inspections, to send out engineers, to do anything you want. And, but by the end of this deadline, we're going to rip off this roof and put on a new one. So if you don't do it, you can't come back later and complain, that we spoiled their evidence or that we didn't give them an opportunity. So, but that's always, I tell people, if you're going to do something like that, make sure you give the insurance company plenty of time to investigate. They have the right to do that. And if they, don't respond, let's say it's a remediation job, then make sure you document everything and photograph everything. It's so important to going back to the very beginning of all this, it's all, documentation is important, whether it's your contract, having your contract written up the right way, calling it a work authorization, or, photographs and measurements and, you understand, moisture logs, all that stuff. It's so important to make sure that you keep track of all that in the right way.
That's great. And Dick, I want you to chime in, but I'm going to ask one more question to Harvey, then I want you to chime in if you're willing to share about your own personal experience on your roof situation and how you were treated by the carrier. But Harvey, I just wanted to ask one last question in regards to what we're just talking about. The language in most policies either says fair and reasonable or a term called reasonable and customary, things like that. How far outside of Xactimate, and I know this is a very general question, but how far outside of Xactimate could you make a legal argument that still falls within, like let's say an Xactimate air mover is 2850. We can go to 30, 31, 32, but if we go to 50, is that too far? Is that not considered any reasonable? Just if you can give our members just a general guideline, and I'm not saying give them an exact percentage, but just a general guideline of what in court you have found has been considered fair and reasonable.
Okay, I'm going to give you the attorney answer, and that it depends. So unfortunately, right there, I have no idea. Honestly, I have no idea what's reasonable. This is, what we think is reasonable is whatever a jury tells us or a judge. So that they're the ultimate, finders of fact. And when you go down that road, if, you do actually go all the way through litigation, many times, juries will kind of cut the baby, right? So you have one that's, Xactimate says it's $28 and you're charging $50. Well, maybe we'll give you 40. I don't know. So whatever it is, but they'll kind of figure out for themselves what's fair and reasonable. And ultimately, so here's two things. Number one is you always want to be fair and reasonable. We all want to have dealings with each other like that. And whether your pricing in the insurance company's mind is too high, that's irrelevant. It's really, can you come to an agreement? Okay, yes, we do charge $50 for this and you want to pay 28, but can we come to an agreement somewhere in the middle that, you can fairly compensate me for the work that I've done or that I'm going to do for your client and resolve the claim without having to hire an attorney, and hopefully, if the insurance company is reasonable and you're reasonable, it can work out. I mean, that happens probably most of the time. Unfortunately, you might deal with the same insurance company 100 times and get a reasonable rate from them. And then you deal with a different adjuster and they don't want to pay you anything. So, sometimes insurance companies are schizophrenic, they'll pay for this and this and this, but not this for some reason. And you don't even know why. Yeah. So
crazy.
And I would, talking about pricing and how to be paid. And this is another thing that I would tell people, especially if you're going to rely on, Xactimate or other pricing guidelines, whatever it is, the difference is I tell people also, you need to be very detailed and complete. If you ever go, and anyone that watches this later, if you're taking an Xactimate class and they give you the problem and go, here, write up this, in Xactimate. If you ask them, what's the most I can charge for this? And what's the least I can charge for the same thing? The instructor's head will explode. So So that's always a good question because, and this is the example I give. I go, look, if you have a light fixture that costs $200 and you might write it down $200 light fixture, or insurance company might estimate it 200. But is it 200? No. First, you need to find somebody in your office that's going to track down that exact lighting fixture. Then you're going to have to hire an electrician to take it out. Then you're going to have to remove it from the ceiling, which might, cause the drywall to crumble. And then you're going to have to repair all of that. Then you're going to have to re-stucco it is, or whatever, like the flat down stuff. Then you're going to have to repaint the entire ceiling to match it. So now it's not 200, it's 2,000. And both answers are ultimately true, right? It is, it could be 200, or if you go through every single little detail, it might be 2,000 or whatever the number is. But that's my point, is that I think a lot of people leave money on the table by not being very thorough and complete in their estimates and in the way that they write up every little thing. Don't just go, oh, here, paint, $100. No, you have to think about the prep and just everything that goes into it and everything that surrounds that. So that's another just kind of a tidbit that I like to do.
Is we're always constantly making sure that as contractors, we're not trying to interpret the policy, but we do understand sometimes that the language says that the homeowner policy really is a reimbursement policy for incurred costs. Can you talk a little bit about that whole issue and whether or not it would make sense for us to try to recommend to our clients that they pay us our invoice, and that would give them a greater success opportunity of getting back all of that money on our invoice? Could you just address that a little bit?
Okay, so let's start at the beginning. Like you said, it's very, if you talk about any kind of policy language or try to interpret a policy in any way, you're walking a scary line. I would stay away from that as much as possible. If they ask you any questions about things like that, you need to probably direct them either to an attorney, a public adjuster, or even their own agent and say, hey, what does it say in my policy about such and such? I've seen contractors interpret policies all the time and say, oh, you're going to get paid ALE and you're going to get paid this, and you have this type of coverage and you have mold, so I tell them they need to stay away from that. Even if you know what the answer is, you could be in trouble by providing any type of policy interpretation without being either a public adjuster or an attorney. So you need to steer away from that. As a contractor, though, I would say that it is beneficial, obviously, if you can, if they have the money, if they can pay you up front, and then you don't have to deal with the insurance company. I don't know if saying these type of words is really interpreting a policy, but you may be able to say something like this. Listen, the way to handle this is your insurance should cover this. You pay me my invoice, and then you go back to your insurance and have them reimburse you. You know what I mean? You're not saying they're going to reimburse you. You're saying the way to handle this is this. You pay me, you're my client. You ultimately owe me the money anyway, not the insurance company.
Right.
And so
I was going to say, avoid any conversation about the policy.
Exactly. Yep. And just say, exactly, hey, we have a contract together. Obviously some people will say, I don't have the money to pay you. And and that's a business decision for each contractor to decide, okay, well, I'm willing to do the job now and I'll wait for you to get the insurance proceeds, but this is my bill and you're ultimately responsible for it, other than your deductible, which they owe you, or whatever the reimbursement is from the insurance company, they're not going to get that part back.
Okay. I appreciate that.
Sure.
My last line of conversation ties into something that's becoming more and more prevalent on the restoration side of our industry. And I was hoping through your experience, you'd be able to shine a little light on it for those of us who are dealing with it and kind of suffering through it.
Sure.
And it deals with the topic of peer review. For those of us who don't do work within a program, we're kind of treated a little differently because we work independently. We don't work within set parameters that the programs or the TPAs design. So a lot of the carriers these days are putting forth peer review companies or third parties that are going to review our invoices.
Sure.
Inevitably, they're hired with the specific purpose of lowering our invoice by any means necessary. And I know you've done a ton of work on behalf of restorers over the years, and I'm sure in many of your litigation cases, you've been confronted with expert witness or peer review type. What would you recommend to independent restorers as the best way to handle those communications? Because we've gone all the way from don't ever talk to them to now where the insurance company says, well, if you're not going to talk to them, we're just going to issue a check for what they recommend, and you're going to be kind of out of luck. What would you recommend to those who kind of have to deal with that on a regular basis?
So ultimately, and I'm talking about cases in Florida, like I said, and well, we can talk about two different things. One would be the direct rep contract, in other words, where you're hired by the homeowner or asset owner, and they are responsible for paying you no matter what. So the bill is the bill, and the insured still owes the contractor the full amount of the bill for their services, or the reasonable amount. So if you have that situation, and I think that is also kind of a business decision. Do you want to get involved with talking to a peer review person when you know exactly what they're going to say? They're going to say, oh, you don't need this and you don't need that, and that's too expensive, and why did you have to have a DU or air, whatever they want to say. So that's one issue when you think about it from a contractual basis. Is, as a contractor, you don't have anything to do with the insurance. You're working for a homeowner. The homeowner has a policy of insurance that they need to deal with their own insurance company and be reimbursed, like we talked about fully. Obviously, it's my opinion, I'm an attorney, but that if in the best world that we could all wish for, is that the insured pays the contractor, and then the insured goes to the insurance company and seeks reimbursement, and they give it to them. That would be great. Or that's not going to happen. So the homeowner pays the contractor, they go to the insurance company. If they don't pay them 100% reimbursement minus their deductible, then they need to seek legal advice and see where they can go from there. And we're lucky in Florida that we have a thing called the fee shifting statute that allows us to go collect the money for the homeowner and give it all to them, and then get paid on top of that. So, that they don't have that in every state, but in Florida we have something like that if you're involved in litigation, you can actually collect the full amount for the homeowner and your attorney's fees on top of that. So that's one issue. The other issue, I think, would be people that still use an assignment of benefits. If you use an assignment of benefits, there's certain cases, and we're talking about Florida again, that says even though you have an assignment to get all the funds and proceeds and all the good stuff, you still don't have to abide by the policy if it has some kind of requirements for the homeowner. That's still their obligation. Now, a contractor can accept those, like that the cases that I'm talking about are more for EUOs, where insurance companies used to go to contractors and say, hey, you have an assignment of benefits, so now we want you to sit for an examination under oath. And you can accept that responsibility, but it's not your responsibility. It's the homeowner's responsibility.
Okay.
So in that same situation, I think all of those come down to, it's a business decision, and probably the more you do it, or, this is how everything else is. You're going to talk to this certain company or this certain, peer review person, that some are going to be good and some are going to be horrible. And you just, move your cases like that. But ultimately, the most important thing for every contractor to remember is that your contract is with the homeowner, not with the insurance company.
Great. And I really appreciate that. That's going to be very helpful for our guys to hear.
Yeah.
The final thing I wanted to bring up with you is something that you wanted to share with our members and our viewers is, should we decide to want to be part of the process with the homeowner and help them out, it's very important to have the legal right to do so. And whether it's the adjusters or their parties or even the mortgage companies, we're going to need to get express permissions. Why don't you discuss a little bit of the form that Dick just put up on the screen for us?
Okay. Well, years ago, somebody, there it is. Not somebody, many people said, what do we do, Harvey, when we get a check and it's our name and the mortgage company's name? And exactly what you said, Bill, is that they cannot, without some kind of written documentation, a mortgage company is not going to talk to you. Even if you have an assignment of benefits, that only has to do with insurance and the insurance company. That doesn't have, the banks don't have to abide by any of that, but insurance companies do. So that the draft that we put together there for everyone to use is just that it gives the contractor the authority to discuss the claim with the bank. And the real reason that we put that together was for more of like the larger jobs. For example, if you're going to rebuild a kitchen after you do mold remediation, for example, you're going to need to know how the bank pays you and who pays you and how does the forms come. So you have that, and that allows you to discuss the claim with the bank and say, listen, I'm the contractor. We got a $75,000 check that I signed over to you. I need you to tell me, how do you pay this? Do you pay 1/3, 1/3, 1/3? When can I expect the first draft? Do you need an inspection? Do you need a final inspection? Things like that. And that just allows you to and this is what I tell people all the time. If you do a little bit of legwork up front, it will save you hours and hours after the, sorry, I got another call coming in, after the claim has been, essentially resolved. So it's a great document.
Yeah, that's really, really helpful. Tied into this works great for companies that are considered turnkey or a full service company. Works fantastic.
Right.
How do we go about, if we're a mitigation company, which is happening more and more, the insurance companies are combining the mitigation and the repair money into a single check being issued to the mortgage companies as well. How, as a mitigation company, are we able to convince them that we're done, we have nothing to do with the rest of the money, release all of it to us?
Right.
Do you have any, sage advice for us to handle that issue?
I do. And what I think you're talking about is you come in and you guys are doing, the mitigation or, drought or mold, whatever it is, some kind of emergency service, and someone else is going to come back in and do the rebuild. Is that right?
Correct. Yes.
Okay.
And then and then what ends up happening is the adjuster takes our invoice, takes the estimate from the repair company, combines them, issues one check that sits at the mortgage company. They then don't delineate between the different services and lump sum out their third. How do we, as the mitigation company, say we're 100% complete? Our money should be issued immediately to us.
So it should be covered in a separate part of the insurance policy. There's a difference between emergency services, which should be covered under coverage A, and the rebuild. So that's what that our argument was always, that our clients, all of our, when we were doing AOBs before they changed the law, but when we did that, that was our argument, that they shouldn't be in the same check. The whole entire check should be written to our client, the mitigation contractor, and that should be under a different coverage. And we can't force them to do certain things, but that should be it. And the other thing that people used to really get upset about was, the mitigation contractor would go in and do their job, and then for like, I don't know, 7 or 10,000. And then the contractor who's going to rebuild would send in a bill for, 50,000. And then they would take the deductible out of the mitigation contractor. And that's a problem too, but really, it's kind of that same thing. You can't force them to take it out of one pile or the other, but they should definitely be writing 2 separate checks.
Okay.
Yeah.
Right. When they don't, do
Mhm.
we have the right as a contractor, once we get your consent to discuss claim, do we have the right as a contractor to then start discussing things like the summary of loss page as proof for us that the monies are different, or are we now
No.
treading back into that policy area?
I would stay far away from that. And what's going to happen is a public adjuster is going to hear about some contractor that's saying that kind of language and report them. And then they're going to get investigated and prosecuted for acting like a public adjuster.
Gotcha.
So, the rules have changed and they've become more strict. And my concern with all of that really is that the contractor isn't acting like a public adjuster. They're not trying to help somebody get paid so they can take 20% of their money or any of that stuff. No, they're just trying to get themselves paid for the work that they've done.
Exactly.
So that does bother me about that, and there are certain things that you can discuss, and I'm talking about in Florida, there's an exception in the public adjusting statute that says, a contractor can discuss their claim and or their scope of services. So, but I would still stay away from any kind of, payment provision that's inside the policy.
Great. I appreciate that, Harvey. Thank you.
Sure. Yeah.
Dick, that's all I've got. Is there anything you want to add or ask Harvey, and personal experience or anything else?
Two quick questions. I think they're quick. One,
Okay.
and obviously it's going to be different for Florida than other states, but I just had a call this afternoon from a longtime friend who happens to be a PA, a public adjuster, and he had a claim in his own home and ultimately sued the insurance carrier. And in Ohio, you can sue the adjusters themselves personally. And they did. Of course, the insurance carrier came back and tried to move it to federal court, which would have taken the adjusters out of the mix. They weren't able to get it moved to federal court, and so they won the claim. So now the judge is determining the kinds of damages that the adjusters will be responsible for. And they mentioned treble damages and so forth. But is that adjuster liability becoming more common, and is it available in Florida? This was in Ohio where this took place.
Well, I'll answer it this way. So first of all, people say, "Oh, you can't sue somebody for that," and I go, "You can sue anybody for anything. That doesn't mean you're going to win." So, can you include an adjuster in a claim against an insurance company? Yes, we've named adjusters personally before when we filed lawsuits when they were acting in a certain way. You get those that they're after the client, that they're not going to pay their bills, or they're going to badmouth them in front of the clients, or tell them things like, "Oh, these guys are a scam," or "They're crooks," or "Look at their, look at their dry out bill. It's $7,000. All they did was throw a fan in here for a couple of days." You know how they love to make it seem like that the mitigation services are never worth what the proper billing is.
Right.
But anyway, so the answer is, yeah, you can, and I'm talking about Florida, you can include someone like that, but ultimately the insurance company is going to be responsible for paying their fees. And in Florida, what we do here is that would essentially become a bad faith claim. And the way to do that is you have to file what's called a civil remedies notice first. And basically you say to the insurance company, hey, you guys are not acting in good faith and taking care of the client according to your contract. So you give them time, you say the way to cure this is this, whatever it is, pay the claim, kick this adjuster off of this case because he's not doing, he's not following the standards, something like that. And you give them an opportunity to do that. And then if they don't, then you can sue them for bad faith.
Okay.
Yeah.
Yeah. The last question, I think the last question that I have period is, Harvey, we know you're active and involved in Florida, but obviously Bill and I work with clients all over the U.S. From Washington State to Texas to New England and down here in Florida.
Right.
Are you part of, or do you have connection with other attorneys in other states where we could say, Harvey, we have a client in Indiana. Is there somebody that you can direct him to help?
Well, not Indiana, but yeah, some places, yes. Like I know people in California and Georgia, Texas, Colorado, but places like that I can think of off the top of my head. But I tried to put together a network years ago of attorneys all over the place. And I have my office call attorneys. First of all, it's hard enough just to find someone that understands property damage and that practices in that area. And then even when we said, hey, we're trying to put together a list to help people. It doesn't cost you anything. You don't have to, this isn't some kind of, advertisement. I'm just putting together a list that I can share with contractors nationwide. So if they have issues like that, we literally had to beg people to say, can we just put your name on a list with a phone number so that people could call you and you can get business out of it? So that was hard. We had that. And that must have been 15 years ago or more when I did that. And I was doing that, when I was doing presentations with RIA nationwide, and so I was trying to help as many people as possible, but it's hard to even get, to find someone that knows about this business but I do have some. If you guys ever need me, if you know how I am, you guys, Dick and Bill, that you can call me or text me anytime. Yep. And if I can try to find somebody for you.
Okay. All right. Bill, anything else for you?
No, I just want to thank you so much, Harvey.
Yes.
I don't think our members understand just how valuable this time that you've been able to share with them is going to be for them, and how it's been for us at Crest. We really appreciate your time. We appreciate everything you do for the industry, because we know how the deck is stacked against homeowners and against restoration companies. And we really appreciate the fact that you're out there on the front lines every day fighting for all of us. And thank you so much for sharing your time with us.
I appreciate it too. And you guys just do an excellent job. And so thank you so much for having me on.
Thanks, Harvey. Thanks, Bill.
All right. Bye, everybody.
Bye-bye, guys. Thanks.
Bye-bye.
Bye-bye.